Good morning and welcome to Rowan University's Forum on Assessing the Legalization of Cannabis in New Jersey on its 2-year anniversary. Can you hear me?
Yes.
Good. I'm Nawal Ammar. I'm the Dean of the College of Humanities and Social Sciences, and I'm just a symbol. I've done very little work, and I want to start thanking people who have done. You can't hear me still? Do I have to speak into this? Okay, that's fine. Can you hear me now?
Yes.
Okay, better. So, Rowan, I was saying that I would like to give you a little bit of a background about why we're here today and how we're here today, and then thank the people who have put a lot of effort in doing this. There will be more people coming in, I promise, and we have streaming, but the streaming, there will be no Q&A in streaming. They'll just be watching us, so just FYI. So Rowan University established the Institute for Cannabis Research Policy and Workforce Development in 2021. January 2021 we started. We were working on it before. And the Institute is an umbrella of 3 centers. The Center for Cannabinoid Science and Therapeutics, Center for Cannabis Workforce Development, and our center, Social Behavioral Security and Law Enforcement Cannabis Center, which is organizing this in collaboration with the Rowan University Institute for Public Policy and Citizenship. I just saw Ben. Okay, he's not here. And the newly established Sweeney Center for Public Policy, and the college of which I'm the dean, the College of Humanities and Social Sciences. So this has been quite an effort, as much as people doesn't look like it is, but it has been. So before I introduce the moderator of the first panel, I would like to acknowledge people who made this forum possible. Where is Kim? Dr. Kim Hauser, who has really shouldered the biggest part of organizing, and she's a professor of law and justice and the director of this center. Tina Kane, where's Tina?
Tina.
She's right there, sitting in the back. Tina has really done an amazing job, and Tina is the administrative assistant in the Office of the Dean of College of Humanities and Social Sciences. Jessica Polch, where's Jessica's right there. And Jessica is the Assistant Director of University Events, Office of the President. She has really organized us. And Will Mendez, where's Will? He's the back there. Will is responsible for a lot of the nice-looking things around the room, and he's the media coordinator in the Office of the Dean. And of course, our students who have been registering people and who have taken care of the parking for the panelists. And last but not least, I want to thank somebody who's not in the room who will be coming, and that is our General Counsel, Melissa Wheatcroft, Esquire, who has really taken care of us at the level that nobody sees. She organized us very smoothly. She pushed things that needed to be done. And of course, I want to thank all the panelists that are going to be speaking to it now and later on. So thank you all for being here as well. Moving on now to the program, I'm happy to introduce our moderator, the moderator of our first panel, and that is Dr. Joseph Johnson. Joe Johnson is a professor in the Department of Law and Justice, and his research areas are many, but the ones that I'm going to mention here are about understanding the criminal experiences and pathways and community violence prevention and programming, as well as a focus on juveniles. He has lately been more focused on, I'm assuming, what you want to call media, mass media, and or social media and crime. So he has done a lot of interesting things. He's shadowed gang members. He has developed a nonprofit youth development and violence prevention organization. He's been a professor and is now an active member of the center. So I'm going to introduce you to him, and he's going to take over. You want to come here?
Well, good morning. Welcome to our first session, our first plenary session, and our first panel. Before I get started, maybe I'm just going to hold it, I'm sorry. Before I get started, I first want to say thank you to Dina Marr for the introduction. And I also do want to thank all those people who had been working behind the scenes to get this program going. And in particular, I want to thank Kim Hauser, who has been sort of my point person and our point person, really. And she just did a really fantastic job of organizing people who are very enthusiastic about the topic or topics that we're going to talk about. And generally, those topics are, cannabis, employment, small businesses, and drug testing. But finally, though, I'd like to thank our panelists for taking the time to come out to Rowan University and for, sharing your knowledge and experiences and just really, again, your enthusiasm with the topic as I've been meeting with you over the weeks. So thank you very much. Before we start, I just want to give a brief introduction here. I don't see the title of our, is there one more before that, sir? There we go, thank you. So the title of our panel is, I can't really see, Implications of Cannabis on Businesses and Workforce. And, next slide, please, but why are we here? What is the issue? Well, the idea is that cannabis has been deemed illegal for over 5 decades now. It's essentially a Schedule I drug under the federal government, and really what's happening is the federal government then has been regulating cannabis for these 5 decades. So cannabis is being linked with other types of drugs such as LSD and heroin, and ultimately fall then under this Schedule I drug or within the Controlled Substances Act of 1971. And what's interesting is the fact that we have states now who are going beyond the federal government, and they're adopting different forms of cannabis within each individual state, and they themselves are regulating it by themselves also. So there's kind of like a mishmash of what's going on between states. Next slide, please. Interestingly, what's happening is there's sort of a changing landscape where more and more people are trying cannabis and more are utilizing cannabis medically and recreationally. And that's going to actually, for us in this panel, that's going to impact employers and even small businesses. In terms of small businesses, they're kind of rearing their heads, asking certain questions. Why is this important to us? What are we supposed to be doing? What is the state's framework or sort of roadmap for us as we move forward? So essentially then what we have is this sort of changing landscape and mainstreaming and normalizing of cannabis over really in a very fast, short period over the past 2.5 decades. In fact, if we can take a step back, or move it forward, but sorry. If we can take a step back just for 1 minute here, just to take a little bit of time. According to public opinion polls from the Gallup poll, the research, the Pew Research Center, the General Social Survey, the support for cannabis legalization has been and is on the rise. In fact, in 1969, 12% of Americans pushed for legalization of cannabis. By moving forward, by 2005, that increased to 36%. And now, according to these polls, most recent sort of closed polls, in 2021, nearly 90% of Americans are in favor of some form of cannabis legalization. So these changing perceptions are also mirrored by the industry's just general growth overall, but specifically here, the industry is growing legal sales of medical and recreational marijuana, as well as the many products that are being put out now across many sectors. So it's obviously a big industry. And just in 2016, about 6 years ago, the U.S. cannabis sales was about $6.7 billion. By 2021, it was around $26.5 billion. And now we're projected by 2030 to bring in as much as $100 billion from this industry. The industry is also carrying a lot more weight in terms of support for full-time equivalent, jobs and employment. So it's a very important sort of sector in the overall industries. Currently, though, medical cannabis is legal in 37 states and the District of Columbia. Recreational cannabis is legal in 19 states, including Washington, D.C. and Guam. And all of this, and there are literally still 9 more states that are planning to take cannabis to the polls and put it on their docket in the near future. So for us today and this panel, what about the changing landscape in terms of employment, in terms of businesses, small businesses, and then even sort of what role does drug testing play as we move forward? So as cannabis expands in more states, becomes more accepted, and the use becomes more widespread, drug testing for employers is going to be one of the big issues and policies that are constantly going to be changing and evolving as we move forward. And here to help us begin to think about cannabis and employment, the employer and the employee, are our distinguished guests. I'm going to introduce each one very briefly, and then we'll move through the panel with questions, and they'll go a little bit further in terms of their own personal introductions. But to my left is Ruth Rauls. She's a law firm partner with Saul, Ewing, Arnstein, and Lear. To her left is David Reinman, who is the ADR coordinator, or the Alternative Dispute Resolution Coordinator for the U.S. Employment Equal Opportunity Commissions for New York's District Mediation Program. And then last but not least, definitely not least, is Sir David White. He's the director of the Conflict Management Program at Seton Hall University's School of Law program. So again, thank you very much for being here. And if we don't mind, to start off, may I turn to Ruth here for a second. And again, if you don't mind, could you further introduce yourself? And then thereafter, could you kind of start us off by providing us with the current legal landscape in New Jersey with medical and adult cannabis use, and then the provisions that deal with employers specifically on this topic?
Well, first of all, thank you very much to Rowan for having us today and inviting me. And I'm excited to be on this panel with some colleagues and new friends that I've met that are interested in this space. As Joe said, I'm a partner at Saul, Ewing, Ernsten, and Lair, and asking a lawyer to talk about themselves is just the easiest thing ever. So I could go on forever about that. But I've been with the firm for about 14 years. My background is litigation as a labor and employment lawyer. I sit in our Princeton office. I'm a vice chair of our litigation department, and I'm a member of our cannabis law practice group. And I always say that I'm somewhat of an accidental cannabis lawyer because as a labor and employment lawyer, I started getting calls around 2018, 2019 from my clients saying, hey, I have this person that we sent for a pre-employment drug test, and they tested positive for marijuana, and they gave me this card and said that it was okay for them to use it, and what am I supposed to do? And hence, I fell into the world of cannabis regulatory, medical use, and now with adult use, and kind of looking at what those things mean for employers. So I very much approach this from a management side, employer obligations, employee protection standpoint. So that's really kind of how I fit into this space and what I do. So with respect to the legal landscape in New Jersey, it has sure changed a lot since I first got that call. So we have had medical cannabis in New Jersey for a while. It's been a depressed program, and it really took off in 2019 when the governor signed the Jay Koenig, and he expanded the medical statute. And it provided a lot more protections to employers, or to employees, and some obligations for employers. So that's the medical statute. And the medical statute has different language than the adult use statute, which I think has probably taken over in terms of what we hear about a lot now, which is CREMA, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. I took the responsibility of saying the full name, so my panelists can now refer to it as CREMA from going forward. And that statute also contains language with respect to employer obligations and employee protection. So First, I'm going to level set. Neither statute in New Jersey requires employers to permit employees to come to work impaired, to utilize cannabis on the work site, to possess cannabis on their work site while they're working. So that's the threshold issue. That's a gating issue in terms of what employers have to do. But then it creates all of these other issues for how do we figure out if we have someone that is impaired. So under the J. Koenig Act, there's some language about if you get a positive drug test, you have to go back to the employee or potential employee and say, hey, do you have a reason for this? They give you the card. That is presumptively, although not in the statute, most likely a reason to not take the positive cannabis test into account. But then we have the adult use statute, and the adult use statute has a lot more language in it. And I would say that the adult use statute is kind of my bumper sticker for when I talk about drug testing in cannabis. Presence does not equal impairment. That is very, very important. I think most of the cases that we have seen come across from employees and what the courts have said is presence of cannabis in a drug test does not equal impairment. Why is that? We do not have an acute intoxication test for cannabis. So I cannot have someone blow into a breathalyzer and find out if they are impaired. So therein creates the issue, right? So when we look at CREMA, they specifically wrote into that statute that presence of cannabinoid metabolites in a drug test, in a blood test, urine test, whatever you're doing, is not sufficient for an employer to take an adverse action against that employee. Adverse action means something to me because this is what I do. Fire, refuse to hire, terminate, whatever it is. You can't do that based on a drug test alone. But it says you have to have more. So what's the more? The more is some evidence of impairment. So it defines a drug test as a chemical test, meaning urine test, blood test, and, bold, underline, and, some type of evidence of physical impairment at the time. Now, that's a big question because what is that? The statute lays out some language with respect to a WIRE, a workplace impairment recognition expert. Did I get that right, David? I feel your eyes boring into me. But we don't have that stuff yet, right? So there is a recognition in the statute that there has to be something more than a positive drug test alone for an employer to do something. We don't know exactly what that something more is. We'll talk a little bit about the guidance that the CRC, the Cannabis Regulatory Commission, has put out, and we can talk through that. But that's really kind of the lay of the land with respect to employer obligations and employee protections on the face of the statute. Now, the rubber hits the road on how you deal with that in terms of policies, but that's kind of the basics for setting the table for the rest of our discussion today.
Nice, thank you. Sort of turning the baton here, or handing the baton off here, David. So in terms of cases related to alleged employer violations of the New Jersey recreational, adult cannabis use legal legislation, what is the likelihood that these types of cases will show up in Philadelphia or New York?
Mike, can you keep the mic closer to
Yeah, sorry. Oops, sorry, David. All right, I'll re-ask this question real quick, but in terms of violations of New Jersey's adult recreational cannabis legislation, what is the likelihood that these types of cases are going to show up in, your Philadelphia or Newark's EEOC offices?
Great. Thank you, Joe, and thank you to the university for having us. Thank you, Kim, for having us as well. Greatly appreciate it. So let me just first explain what I do at the EEOC. I'm the Supervisory ADR Coordinator for the EEOC's New York District Mediation Program, and our New York District entails all of New England, New York, and most of New Jersey, so about the central counties of New Jersey all the way up. And then our Philadelphia District Office handles the lower counties, or the southernmost counties in the state of New Jersey as well, and they're right across the river here. So, and part of our program is bringing employees and employers together in an effort to try to help them resolve their active charges that have been filed with the EEOC. Now, the EEOC is the federal agency that enforces the laws against discrimination in the workplace. It's obviously illegal to discriminate against a job applicant or an employee in the workplace because of a person's race, color, religion, sex, including sexual orientation, transgender status. national origin, age, disability, and genetic information. So those are the statutes that we cover at the EEOC, right? So to answer your question, Joe, in terms of the likelihood of New Jersey's adult recreational cannabis legislation and violations thereof coming before our agency, given the fact that cannabis is still illegal federally, there's likely no chance that we're going to see those types of cases at the EEOC until maybe it's deschedulized on a recreational level. Now, that's not to say that these cases haven't come before our agency on it from a medical perspective, because we've seen medical cannabis cases, like, for instance, violations of the Americans with Disabilities Act under the ADA come before our agency. So just because medical cannabis, for instance, is still illegal federally, that hasn't precluded our agency from pursuing actions or investigating cases where there's a violation. Now, per se, for instance, the ADA, the statute that I'm talking about right now as it relates to medical cannabis, does not provide protection to individuals under that statute for the current use of cannabis. However, there are instances where somebody is being directly discriminated against due to their disability, not necessarily the failure of a drug test for cannabis, where our agency has pursued those types of cases. I'll cite, for instance, EEOC versus Pines-Clarkston. That's a case out of the U.S. District Court in Eastern District of Michigan. And that case involved an individual employee with epilepsy, and she had failed a cannabis drug test. And the employer cited that test in their decision not to hire that individual. But what had happened in the interview process is they were grilling that individual about her epilepsy. So it was direct discrimination related to her disability, not the fact that she had failed a drug test, right? So the EEOC is looking at that and those nuanced issues as to whether or not they will actually pursue these types of matters as it relates to medical cannabis. In that particular case, the case settled out of court, so we don't see where it actually went as it was litigated, but the parties settled for $42,500 and also a 4-year consent decree settling the suit, which provided the institution to establish policies related to disability discrimination and things of that nature. So it's not as if the EEOC, just because cannabis is illegal, is not pursuing such actions, but you'll see that possibly under the ADA. There are instances as well where we look at the ADA as it relates to drug tests, and the ADA limits employer access to and disclosure of medical information about employees and applicants. But the ADA specifically states that a test for illegal use is not a medical examination, whereas a test for alcohol use would be, right? So where this could open up is if it was deschedulized, maybe we will see cases falling under this particular element, or drug tests, for instance, coming before the EEOC for medical use as well. So you may see that come down the line. We talked about the statute not covering current illegal drug use. But under the ADA, it's possible that somebody has possibly recovering from a drug addiction that could be covered, that could be looked at as a disability, right, and fall under the ADA. But the question that Joe had asked is related to recreational use. But so for right now, if somebody were to violate the New Jersey legislation on recreational cannabis use, we're not going to see those cases. We're looking specifically on what I had just listed related to the medical cannabis and how that could possibly pop up at our agency. So as it relates to New Jersey legislation on recreational use, no, we're not going to see those types of cases. So.
Very good. Thank you, David. If you don't mind for a second, I'm going to ask you to sort of take off your federal EEOC sort of hat and put it aside. So I'm looking for just your perspective, not the organization itself. But so Ruth, for us, she laid out some of the laws that are in place, and I wanted to give you sort of a hypothetical, and then again from your perspective, could you kind of let us know your thoughts or how you see this situation actually playing out? And the hypothetical, I kind of added a little bit to it, so there's a couple of key pieces. But on the morning of September 10th, 2022, Larry Landscaper, operating in New Jersey as an LLC, or limited liability corporation, is providing lawn cutting services to a client. The client, who is home at the time, comes outside and asks Larry, "Hey, I noticed you only have 2 of your staff on the job. Where's your third employee, my guy, Stevie Stoner?" And Larry Landscaper replies, He showed up this morning stoned. His eyes were glassy and he reeked of weed. I sent him for a drug test and I just said, F it, I fired him. And so Larry Landscaper made this determination based solely from his own personal observation and nothing more. Stevie Stoner is an employee at will. And so Stevie Stoner, believing his rights have been violated under the New Jersey's adult use cannabis legislation, hires an attorney. So from your perspective, David, how do you see this situation progressing?
Great, excellent. No, this is fun when I get to take off my EEOC cap, and I just want to have the caveat that anything and the views that I express here as a legal disclaimer, lawyers have to lawyer up everything, right? So as a legal disclaimer here, none of my viewpoints here or anything that I express under my current hat as Stevie Stoner's plaintiff's counsel are not that of the EEOC, right? So I just want that to be very clear. Now, first, Stevie Stoner is going to come to my office, and I'm going to sit down with Stevie Stoner, and I'm going to talk to him about what had happened, and obviously finding out that Stevie Stoner is of age, 20 years or 1 years or older, and he wasn't using cannabis for medical purposes. He was just availing himself of his right under this new legislation related to recreational cannabis use. I quickly determined that Larry Landscaper has likely violated the laws that prohibit an adverse action, whereas he was fired, for use of recreational cannabis off-duty. And so Larry Landscaper was obligated as well to show Stevie Stoner was indeed impaired at work and following specific steps as Ruth had outlined. For one, the drug test, whereas in this case, Larry Landscaper sent Stevie to get a drug test, but he had not found out the results. And trying to figure out whether or not Stevie Stoner actually was impaired, and he didn't follow any of the guidelines or anything of that nature. Now, this is the likelihood of most small businesses. So as a plaintiff's attorney, I know this, right? This guidance just came out. We have further guidance that came out related to the wire and ways that employers can find out if somebody's impaired. And this happened on September 10th, and September 9th is when that guidance came out. It's very unlikely.
How convenient.
How convenient, that's right. So as a plaintiff's attorney, I'm totally going to take advantage of this idea that most small businesses are not going to be prepared due to the recency of this guidance and the fact that most small businesses do not have sophisticated human resources representatives within their organization, nor are they attorneys, right? Larry Landscaper is just trying to make ends meet. He's not focused on this. Now, how do I know that? My dad is a small business employer here in the state of New Jersey who probably at any given time has 2 or 3 employees. And he could care less about what's going on in the law. He's trying to take care of his customers, and he's trying to make money to fund his business and pay his bills, right? So he's not keeping track of all of this stuff. And so where this becomes a concern as well, and I'm very empathetic towards small businesses, individually and personally, is that 99% of New Jersey employers are small businesses. And that's huge. Now, that ranges from 1 to 500 employees. So I'm assuming a lot of small businesses may have sophisticated HR representation and things of that nature as they get larger and larger. But here's the kicker. I could guarantee you those employers that have 1 to 9 employees aren't sophisticated. They do not have HR representatives, or they're not aware of the law, and they're not staying privy to all these recent updates related to the law. So we're looking at that point. I think it's the New Jersey Department of Labor and Workplace Development had said that 252,331 New Jersey employers have less than 9 employees. Now, also those that have 0 employees, which make up the large majority of small businesses, they hire contractors. They now fall under this legislation as well, so they can't take adverse action against employees for availing themselves of the right. So I know this, right? So I know they're not prepared for this, and so what I do is I'm going to send. Does anybody know what a demand letter is? Anybody by hands? I know. So demand letter is where I write to Larry Landscaper and I say, hey, I represent Stevie Stoner in this action, and I lay out the laws that I believe were violated. In this instance, I'm going to lay out to Larry Landscaper that, for instance, on September 10th, 2022, Larry Landscaper, you took an adverse action solely based on Stevie Stoner's adult use of cannabis off-duty when you fired Stevie Stoner from his employment. While Larry Landscaper alleged that Stevie Stoner was impaired on cannabis at the work site, Larry Landscaper failed to, under the Act, properly assess whether Stevie Stoner was under the influence of cannabis at the time when Larry Landscaper did not utilize proper procedures to give rise to a reasonable suspicion of impairment, and that Larry Landscaper did not conduct the proper physical evaluation of Stevie Stoner to detect and identify Stevie Stoner's usage of or impairment from a cannabis item or other intoxicating substance, and Larry Landscaper fired Stevie Stoner on the spot without waiting on the results of the drug test. I may therefore, after that, go through all the excruciating details of the Act, the guidance, and things of that nature, as Ruth had laid out. And then my favorite part, as a result of violation, my client has incurred lost wages, emotional distress damages, attorney's fees, and the amount of $50,000, right? Give me a call, let's talk. Now, I may have tried to call Larry Landscaper before this to try to kind of level with him and talk to him, but I can guarantee Larry Landscaper didn't want to hear any of it. He probably hung up on me if he took my call at all, and if he did talk to me, he probably had some choice words and proceeded to hang up the phone. How do I know this? Because that's what my dad would do. I know that for a fact. So I'm assuming Larry Landscaper would do the same thing, right? So that's where we're at right now. So Larry Landscaper gets this demand letter. Maybe at that point he takes it seriously. And I guess we'll assume, for the sake of hearing what employer counsel or Larry Landscaper's counsel would have to say, and I may have a little bit more to say after that, but Ruth, let's assume you get this demand letter. Larry Landscaper is privy enough to call your firm. If he could afford your firm, I don't think he'd be able to afford your firm, but he calls you up, you get this demand letter. How would you respond?
Sure. So so I would get the demand later, and I would say, this is ridiculous. Don't worry about this. No. So a couple things. I would sit down with him and speak to him about what happened, and I would talk to him about the guidance. But I'm gonna start at the bottom of this demand letter first and work my way up to the facts, because for all of those attorneys in the room, if you don't have the facts, you argue the law. If you don't have the law, you argue the facts, right? So the last part of what he said was, I'm going to seek damages for lost wages, emotional distress damages, and attorney's fees. And I said, that is fantastic, except for you're not entitled to that under the statute. Because the statute, CREMA, does not provide for any damages for violation of, for taking an adverse action against an employer. In fact, CREMA doesn't even provide for a private right of action for an individual for violation of the statute. It puts all of the authority for enforcement with the CRC. Does that answer the question? Probably not. There is one case that is currently pending in the Federal District Court of New Jersey. It's a proposed class action with respect to pre-employment drug testing, and the case was filed not exactly on the same type of grounds, but this person was denied an offer of employment, allegedly denied an offer of employment for failing a pre-employment cannabis drug test, and they allege that violated CREMA. There's a motion to dismiss that's currently pending saying you don't have a private right of action under CREMA. So the court's going to decide that question. So if the court decides you do have a private right of action under that statute, we're off to the races, right? So, hey, Larry Landscaper, we've got some problems here because this is going to survive a motion to dismiss if that's the state of the law at the time. With respect to the damages and attorney's fees, there's nothing in the statute that provides those type of remedies. So our risk profile here is lower than what I would say for a case that's brought under the New Jersey law against discrimination, where you do have those type of damages. So that's kind of the first thing in terms of framing the issue. But then let's talk about what he did. So the guidance that the CRC put out with respect to reasonable suspicion, because that's what we're talking about, right? Larry saw our friend. Well, first of all, I just want to object to the prejudicial nature of Stevie Stoner's name, but he saw. Family name. Yeah, it's family name passed down through generations. He saw him, thought he was impaired, and took an action, right? So the guidance says, what I can't do. Well, the statute says this, and the guidance reiterates, is what I cannot do as an employer is send him for a drug test and take an action solely based on that drug test. So that didn't happen here. He did send him for a drug test. He didn't wait to get the results back, but he did send him for a drug test. But really what he did is he made the decision for termination based on his observable signs of impairment. I would take the position that he had a reasonable basis for those observable signs. I would sit down and ask him, what were they? Did you write them down? Can you write them down for me? Tell me what it was that you saw. It's in the hypo. Glassy eyes, he smelled this, that, the other. And then I would say, you know what? The CRC has given us this really fantastic reasonable suspicion form. Now, he didn't fill it out, but all of these things that you've observed are listed in here. So that would support a reasonable observation of impairment. However, Larry probably has some issues because under the guidance, they really do want you to have a specific standard protocol for how you evaluate impairment. That's really what they're getting at. You know, it's not a requirement, it's guidance, it's not a reg, but it says this is what we think you should do. You should have somebody that's sufficiently trained to complete this form, recognize impairment, have it done contemporaneously within so many hours, and all of those things. So there's some issues there. And those are all going to be factual issues that are going to have to be hashed out. But that is the tack that I would take with Larry is one, first address what's the real exposure risk. Not a lot based on the statute and the current status of the law. However, if that changes, we're going to have to dig into the facts, and we've got some issues here with respect to how we did that, and we need some better protocols for going forward.
So I'll just take
Yeah.
So
Rebuttal?
Yeah, so definitely. So at that point, Ruth may call me back, right? And she's going to say, hey, you know, this is hogwash. This is ridiculous. My client's not paying a dime. You know, we'll see you in court. You know, my first response to her certainly would, look, we're open to a counteroffer, right? We're trying to settle this dispute. Of course, coming from a mediator where I believe negotiation should prevail in most instances, I think it makes sense to try to resolve this because sensible business dictates resolving this matter, not just for my client, Stevie Stoner, but for Larry Landscaper, who's a small business, and he likely can't proceed too far into the weeds into litigation because he probably doesn't have the financial wherewithal, the resources to do so. So that probably becomes a problem for Larry Landscaper. Again, as plaintiff's counsel, I know this, right? And I certainly look at it from an instance that it's not actually about whether or not Stevie Stoner was actually impaired at work, but whether or not Larry Landscaper followed the nuanced procedural mechanisms laid out by the adult use cannabis legislation. So that becomes the real problem. But really, Ruth, at that point, given what I know about Larry Landscaper and his propensity to really not know what's going on and really just be hot-headed, he's not going to probably get counsel right away, right? So let's assume Larry Landscaper ignores my letter, he ignores my calls, as I had indicated before. I go ahead and I file a complaint in New Jersey Superior Court. Now, Larry Landscaper is an LLC, right? So as an LLC, under the rules of court, that means that he's required to have counsel in order to file any papers with the court, right? But Larry Landscaper is not going to know that. And he may be up against a deadline. So what happens is Larry Landscaper is going to file on his own, but then he's going to end up in default, right? So now we have an issue there. Because again, he's a small business and he doesn't have the resources like being able to consult internally with a Ruth or an HR representative. So he doesn't know this. But let's assume then at this point, Larry Landscaper, he wisens up, he does get counsel to correct his mistake, and he brings it back forward and he hires counsel. But at that point, he's knee-deep in expenses for attorneys, right, like litigation expenses. I could almost guarantee you that Larry Landscaper as an LLC doesn't have employer protection liability insurance, so all this money is coming out of his pocket, right? So that's a big problem for employers, large and small, when it comes to litigation and defending any type of action when it comes to workplace discrimination. But larger, more sophisticated employers will have that EPLI insurance to cover them as well. But in this instance, Larry Landscaper doesn't have that. So I know, hey, early settlement is probably the best bet. But as the court action proceeds, we get into discovery. Larry Landscaper is getting advice from his counsel. He starts to learn more about the legislation and the hypersensitive requirements related to confirming that Stevie Stoner was indeed impaired at work. And he comes up with this thing about reasonable suspicion. And Ruth asks, did you have reasonable suspicion? Did you file these guidelines? Larry Landscaper says, what do you mean reasonable suspicion? I know what somebody being high is. I've been running a business for 30 years. I was in college once. I used to hang out with my buddies and get high and listen to Dr. Dre's The Chronic, the 1992 classic. Like, what are you talking about? I know when somebody is stoned. So, you go through that, and you certainly, Larry Landscaper, that's going to be his response, right, when it comes to that. So he's going to be very stubborn. We're going to go through these things, and we're going to go into the pre-existing protocols that exist from the September 9th. He's not going to have pre-existing protocols. He's not going to have an SOP. He's not going to have these things into place. Moreover, Larry Landscaper is going to sit back and say, so what? I hired a good attorney, set up my LLC. I'm protected. Nobody can go after my personal assets. But, maintaining, I'm going to say to Ruth, I'm going to say, well, we're going to attempt to pierce the corporate veil. And Larry Landscaper's going to be like, what does that mean? And I'm like, well, maintaining that LLC protection means more than just forming an LLC and filing a registration fee and paying a registration fee. There's so much more to maintaining an LLC. So it's possible that we may be able to go after Larry Landscaper and his personal assets as well. I mean, this is all a possibility, right? I'm not saying that this is, potentially how it will go in every case, but I think what needs to be looked at is certainly that we need to appreciate that this newly enacted legislation and the protections it provides to employees, we appreciate that, right? We honor workplace workers' rights. I think that's paramount. But I think what I wanted to highlight in playing devil's advocate here is that New Jersey small business employers, which serve as the backbone of our economy here in New Jersey, just aren't going to be prepared for the recency of this legislation. Now, we're going to ultimately determine, just for the sake of this panel and time, that the parties agree to mediation, they go to mediation, and ultimately we settle for, what, Ruth, $20,000?
I'm going to win my motion to dismiss, so I don't know what you're talking about, but sure.
So we're going to settle for $20,000, and now Larry Landscaper's incurred litigation costs, his attorney's fees, as well as paying out potentially a chunk of money in order to settle with Stevie Stoner. But, this is, again, we're playing devil's advocate here, and it's just something that, popped in my mind given the fact of the recency of this guidance, my empathy towards small businesses, as well as my passion for employees' rights, and this is just kind of potentially a mess given the hypersensitive requirements. So thank you all for your time. Appreciate it.
Nice. Thanks, David. I just have one more question for Ruth before we turn to David here. We were talking about evaluating impairment, and Ruth, I was wondering if you could introduce us to the workplace impairment recognition expert, or more known as the WIRE. And then, what is your take on it in the workplace environment?
Sure. So I do want to say that by the time Larry Landscaper is at his deposition, he's going to have an excellent understanding of what reasonable suspicion is and be able to describe it in excruciating detail. But I digress. So workplace impairment recognition expert. So an interesting aspect of CREMA in New Jersey, which is very different than most of the states that we've seen enact adult use legislation for cannabis, is this requirement for a WIRE. So the language in the statute says the drug test, right? So we're defining what a drug test is. Scientifically reliable, objective testing methods and procedures, such as blood, urine, or saliva, and remember I did that bold, underlined, highlighted and earlier, and a physical evaluation in order to determine an employee's state of impairment. And then the statute goes on to say that the physical evaluation shall be conducted by an individual with the necessary certification to opine on the employer's state of impairment or lack thereof, and then they can use that to determine the appropriate employment action. And then it goes on to talk about what this person is. And it's called a workplace impairment recognition expert. There's supposed to be a certification for how you become that, so that you can go and help employers perform this physical evaluation, and that the CRC is going to prescribe minimum curriculum courses for these certificates. Well, the CRC hasn't done that yet. What they have done when they put out their first set of regs is they put out a specific reference to a WIRE that says, notwithstanding the provisions of the statute, Until such time that the commission develops the standards for a wire, no physical evaluation of an employee being drug tested in accordance with the wire certification shall be required. So the wire's out there, it's in the statute. We don't have certification requirements yet, but what we do have and what we have been talking about a lot is this interim guidance that the CRC put out with respect to impairment. And it really deals with reasonable suspicion, right? When, what you have to do, what type of physical evaluation, and some practices and procedures. Now, it does not have any specific information about what you have to do. It just has language that says a person should be sufficiently trained to determine impairment and qualified to complete the reasonable observation suspicion report. So, that's up for interpretation. That could mean, I would argue, depending on where I am, that, hey, I sat down, I did a training with this person, I walked through the form, they know how to fill it out, they have procedures for how to do it. That should be sufficient. I'm sure somebody on the other side would say, no, it's not sufficient, you have to do this. So there's an open question there, but the wire is something that is in the statute. Unless the legislature acts to remove that language, it's going to be there, and at some point we're going to get some certification requirements from the CRC. But when we hear that word being bounced around, that's what we're talking about, and it really is unique to New Jersey's adult use statute. There aren't any other adult use statutes that I've seen across the country that have language like this or some type of certification or requirement like this. So hopefully that sets you up, David, to knock it down.
Exactly. Thank you, Ruth. David, now finally turning to you. Apologies for the late turn to, but if you don't mind introducing yourself further for us, first of all, and then kind of going off of Ruth and David and their hypothetical on the employment at will space and with the wire. I just want to ask you, how would the scenario have played out if Stevie Stoner was represented by a unionized landscaper?
Well, thank you, Dr. Johnson. I'd like to begin with expressing a few words of appreciation and echoing my fellow panelists here. To Dina Marr for having us here today, thank you so much. For Dr. Hauser for your visionary leadership in this space, and for Dr. Johnson for agreeing to mediate this panel. By way of introduction, I'd like to say that I am probably the least likely person to be sitting on a cannabis panel. And for a couple of my colleagues who will be joining us later today, I have told this story before. I have never, ever knowingly ingested a THC or CBD infused substance at all. So you might say, well, what could you possibly bring to this panel? And I asked myself that question back in 2018 because there are, without outing people, subject matter experts in this very room that know much more than I do. But having said that, I became the unlikely, unwitting subject matter expert in a very niche field. In 2018, the New Jersey State Bar Association had an opportunity to form a cannabis law special committee, and Ruth and I and Mike Hoffman, who will be speaking later today on our second panel, were among the first 25 people or so in the state of New Jersey to answer the clarion call to think about the public policy implications of what was then New Jersey's medical cannabis program and the wide-ranging implications of an expansion into an adult use space. A couple of terms of art that I'd like to lay down for our panelists later today. We don't talk about marijuana, we talk about cannabis, and we do that because the botanical name of the plant is Cannabis sativa L, and marijuana actually harkens back to a racist time where individuals demonized communities of color, specifically Latin American people, for using that term because marijuana spelled with a J or an H sounded vaguely racist and very scary. And that's the way it was for many, many years, beginning with the 1937 Prohibition Act. So we don't use the word marijuana, we prefer cannabis. And in the state of New Jersey, we don't talk about recreational, we use the term adult use. Occasionally, you'll see administrative gaffes where personal use is slowly but surely creeping into the lexicon, but we do prefer the term adult use. So in 2018, Ruth, Michael, and I were among that 25 or so people that got together to talk about, well, what can we do and what would be a reasoned approach? New Jersey began its medical cannabis program in 2011 with alternative treatment centers. And on this date, 2 years ago, in 2020, 67% of New Jersey voters who went to the polls authorized the New Jersey legislature to amend the New Jersey Constitution to provide for adult use cannabis. So it is indeed an auspicious day that we get together here today. And I'm also particularly enamored of being here because, to my knowledge, and I would invite my colleagues that are similarly situated to think about this, this is very likely the first panel to critically consider the implementation of a workforce impairment recognition expert. And we like that because there's some really heady discussion to be had on this topic to talk about the interim guidance that came forth from the Cannabis Regulatory Commission on September 9th. And as Ruth correctly notes, this is guidance and interim guidance at that. It does not provide for private right of action. So the question really is, for the 312,452 New Jersey employers of record, what does this all mean? And hopefully we'll suss that out as we go. Dr. Johnson asked me, well, what brings me to this space, and a little bit about my background. In addition to serving on the Cannabis Law Special Committee, where I currently have the privilege to serve as the co-chair of the Labor Employment Committee with Ruth, I also had the opportunity from 2018 to 2020 to serve as the retained special consultant to the New York City Police Department on cannabis, to their chief of strategic initiatives. At the time, there was a great question as to whether or not New Jersey or New York would first legislate and subsequently implement adult use cannabis. And the NYPD was very much concerned about adult use cannabis from New Jersey coming into the 5 boroughs of New York City and what would be the implications of those actions. So I got involved with that. Shortly after that happened in 2018, I was asked to contribute some efforts to writing competitive applications for those that wanted to secure licensure. And I ultimately contributed content to successful applications in New Jersey, Pennsylvania, Delaware, and Illinois for what are called vertically integrated operators, those that engage in all 3 major facets of the cannabis industry. That would be cultivation, manufacturing, and dispensing. So against that background, the United Food and Commercial Workers Union, which is the arguably 5th largest organized labor movement in the United States, approached me and asked if I would get involved with them as a subject matter expert to talk about the use of safety regulations in the workplace. So I continue to help them to contribute to what we are very optimistic will be a universal workforce training curriculum, which will ensure health and safety of workers in this space. So more and more, my time became invested in this space as we moved about. And I think that, to Dr. Johnson's question about what is the wire and what implications does it have for a unionized environment, we have to begin with a critical understanding, a first principle, if you will, that there is a distinction with difference between labor and employment. So if you are not among the 14 million Americans that are governed by a collective bargaining agreement representing about 10.3% of the American workforce, you're an employment at-will employee in the state of New Jersey, which means, as Ruth would tell you, you can be fired for good cause or simply no cause, but you cannot be fired, and an employer cannot take an adverse employment action for bad cause. Not so with arbitration. Arbitration is a creature of contract. And I like to say that arbitration is very much like the American Red Cross. It is well known, but not known well. And if you said to somebody, well, what does the American Red Cross do? They'd say, well, when there's a natural disaster or a calamity of some sort, they help people. And when you get more granular and say, yes, but how? They give them a red blanket. I get that. They're hungry. They give them a donut. And they're thirsty. They give them a hot cup of coffee or soup. What else do they do? The red blanket. Yeah, I got that. You told me. And it's the same way when we talk about arbitration. And more, we're seeing a proliferation of organized labor, specifically in the cannabis space. So at the invitation, at Dr. Hauser and Dr. Johnson's invitation today, I am speaking on the nuanced topic of cannabis arbitration and the wire. And I will tell you that if you look at this particular space, the 2 competing labor unions in the United States that are members of the AFL-CIO, which is the large governing body of organized labor in the United States, are the United Food and Commercial Workers Union, who have an estimated 1.4 million members. And right above them in the top 5 is the International Brotherhood of Teamsters, which has about 1.6 million individuals. And those companies have what are called collective bargaining agreements, which is effectively a contract that governs the terms and conditions of employment in the workplace. So the very pointed question Dr. Johnson posed to me was, what would happen if this were a unionized environment with Larry Landscaper and his erstwhile employee Stevie Stoner? And the answer is we'd look to the contract. And more often than not, there is a progressive disciplinary proceeding which would talk about reasonable suspicion in the workplace, about what you can and cannot do vis-a-vis suspension or termination. And in the event that an act of economic capital punishment, which is what termination is, should occur, then that matter would slowly but surely wend its way through the arbitration process and ultimately wind up before a panel of 3 arbitrators or a sole arbitrator. And in the event that Stevie should carry his burden of legal persuasion, the proper remedy would be reinstatement with back pay. So even if he's been out of the workplace for a year or more, he stands to seek redress of his economic injuries. So there is a distinction with material difference between employment and labor law in this state. It's an exciting aspect in which to work. It's one, again, that is not known particularly well, but I do welcome the opportunity to share a perspective with this group today.
Thank you, David. I have a couple quick questions, if you don't mind. So we know that New Jersey has been historically supportive of organized labor and movements. So in a time when union membership is actually declining in many sectors, the cannabis industry is basically an outlier here. Why are we seeing increasing unionizing activity now?
So one of the things we hear a great deal about in our society, as well we should, is social justice and social equity. And if diversity, equity, and inclusion are to be more than 3 bandied about buzzwords that no one really critically considers, then it has to mean something. And when we talk about labor unions, their reason for being today is decidedly different than it was during the golden age of the labor movement in the United States, which I would identify as the 1940s into the late 1950s. I came up as an 18, 19-year-old working for United Parcel Service of America. I paid my way through my undergraduate and graduate degrees by working what I affectionately called low-life to no-life shifts with United Parcel Service, those being from 5 p.m. to midnight or 10 p.m. to 7 a.m. And I can tell you at the time, that was much more akin to the Marlon Brando classic On the Waterfront. There were things that I look back on and I marvel at that we did at that time, and I was a Teamster before I became a labor executive with UPS negotiating from the management perspective. There were things that went on that you would just scratch your head today and say, there's no way that happened, that's urban legend. Oh, it was real. And today, labor is not, if I can be colloquial for a moment, not a lot of D's, Dems, Does. These are credentialed, highly educated people on both sides of the table that are looking for reasoned compromise and often find common cause in workplace safety. And so it doesn't have to be antagonistic. And it's a really outdated paradigm to believe that it's a zero-sum game. And by that I mean $1 from management is $1 to the union membership and vice versa. Today, there's a symbiotic relationship that can and indeed must exist between labor and management. If I were to take New Jersey's cannabis program by way of concrete specific example, if you are going to apply for a license and you are to be successful, at some point you need what's called an LPA, a labor peace agreement. An LPAs effectively do several things, but I'm going to distill them into just 2 things on either side of the conflict. Number 1, the employer pledges to take a neutral position throughout the organizing drive. They will not in any way try to dissuade their employees who are prospective rank and file members from doing something. And in exchange for that position of neutrality, the labor union promises not to have interruption of goods and services. They will not boycott. They will not picket. They will not attempt to have sympathy strikes and the like. So the urban myth, the misunderstanding that I'd like to explode at this point is that an LPA, a labor peace agreement, as I'll use those terms interchangeably here, is an automatic guarantee that there will be a unionized environment. What it really means is that there will be an even playing field for workers to make an informed decision as to whether or not to be represented by a collective bargaining unit is in their decided economic best interest. If the majority of those covered by an LPA decide they would like to be rank and file members of the union, and CREMA, and I thank Ruth once more for pulling the tough task there and defining that term for us, but CREMA talks about the fact that there needs to be a bona fide labor union. And I could bore you with the actual language of CREMA, which I happen to have here, but we're talking about a union that's been around, that's legitimate, that's not subject to questions about its validity. And if you're going to have a collective bargaining agreement, that's a vote taken by the members of the workplace. If this were 1989 and this were my beloved UPS, management wouldn't talk to labor. And I was involved in the 1997 National Master Agreement in Washington, D.C., which resulted in the first 2-week nationwide work stoppage. So I guess we didn't do great for UPS packages. And it took 6% of the country's gross domestic product and ground it to a halt as packages in the sweltering heat of an August summer sat on loading bay docks. Today, that kind of antagonistic behavior, that enmity, that rancor, that adversarial quality cannot exist because there's an undeniably political dimension to what we're doing here, despite the fact, as Dr. Johnson has correctly noted, that public policy, public sentiment militates strongly in favor of cannabis legalization on both the medicinal and adult use fronts. There are still stigmas to be overcome. And if there are patients, there are qualifying physicians. And if, as David notes, there are individuals that are 21 years of age or older that want to avail themselves of cannabis no differently than we might go out and have a cocktail at a bar, there's a stigma to be overcome about that. There are implications in the workplace. There are socioeconomic problems that have yet to be considered. So working synergistically, working cooperatively, working collaboratively, we might have Local 360, United Food and Commercial Workers Union, Local 360, or Local 152 in this part of the state, working together with both applicants or operators to ensure workplace health and safety measures. And I can tell you that the relationship between labor and management is not an uneasy bedfellowship, but rather something that's a really enthusiastic partnership today.
Great. That was excellent. Thank you. I just have one more question, and then we can turn it over to the audience for their own questions. One more, though, Dave, if you don't mind. So currently, the Murphy administration has and points to a commitment toward job creation, skills development, and economic improvement. How does the lawful cannabis industry fit into that larger picture?
New Jersey is among the bluest of blue states. I think we can all accept that as a truism. And historically, Democratic administrations have been very supportive of organized labor. The Murphy administration is no different. So when we look to say about labor peace agreements or collective bargaining agreements, it's a notion, it's a recognition of an idea whose time has indeed come. And one of the things that I've really been very honored to contribute time and talent to is the United Food and Commercial Workers Union Joint Apprenticeship Training Committee. If this were 10 or 15 years ago, we might talk about MIC jobs, right? Disposable throwaway jobs, minimum wage. Today, we're not talking about a minimum wage. We're talking about a living wage. We're talking about careers, not simply jobs. So this isn't a liminal period to work your way from one dead-end subsistence job to another. This is an opportunity to actually acquire training. I mentioned in my earlier remarks that there's 3 facets of vertically integrated operations. One of them is cultivation. And there are schools within and beyond New Jersey that have arboreal programs, horticultural programs, botanical programs, and you have individuals matriculating towards doctorates in plant tissue science. And these are individuals that are not investing 5 or more years of their time to earn $15 an hour or whatever the then prevailing federal or state minimum wage might be. These are professionals that are getting in at a ground floor in an industry that has nothing but upside potential. Conversely, if you have individuals in the middle of the house who do manufacturing or prepare the cannabis for distribution, or the front of the house, the so-called patient or consumer-facing operation. These are individuals that actually want to be able to support families. We were talking earlier, Dr. Johnson made reference to an FTE, a full-time equivalency job, not cobbling together two low-paying minimum wage jobs, but rather having the opportunity to go forward with a job that promotes dignity, safety, and a sense of accomplishment. The Murphy administration has done much to support the cannabis industry here in New Jersey, and there's every indication that that trend will continue. Senator Cory Booker at the federal level is one of the most outspoken champions for a variety of topics. And while I know that the discussion of lawful psychedelics is well beyond the scope of what we're doing here today, remember that I made these remarks on November 3rd of 2022, because 2 years from now, there'll be a prescient reflection on what I'm about to say. The state of Oregon on January 2nd will wind up having their first professional services centers where individuals can avail themselves of psilocybin, which would be colloquially known as magic mushrooms, or MDMA, which might be known in the clubs as E or X or Molly, or ketamine, and we actually have ketamine clinics here in New Jersey. I think there's at least a fighting possibility that New Jersey will be that second state, and it would not surprise me if by the 31st of December 2023, we are in a vastly different place than we are now. Those of us that are thinking ahead along those lines look to cannabis now to see not what the brave new world will be, but what the reasoned approach to both commerce and society will be at that time.
Excellent. Thank you very much. I appreciate that. Now we have about 20 minutes. It ends at 10:50. Is that correct? We'd like to open it up to the audience for any questions that you might have for our panelists. And then just a note real quick before we leave, our panelists will be here after as well. Stick around for a little bit. If you have any personal or individual questions for them, and if you need any emails or anything, I can get them to you myself. So, but the floor is yours.
I'm a manager at the Rowan bookstore, so we employ all of our part-time employees are mostly college students. So I guess this will go back to, can you hear me? Go back to Ruth. So they come in very frequently. They smell like marijuana and, is it on? Sorry, cannabis. And, I'm obviously not a qualified person to say that they're on, So I guess my question is, can we send them home? How does that work? Since we don't have a certified employer that can determine whether they're on something.
Sure. Since the microphone was passed to me the minute you started talking, I think I'll answer the question. So I think it goes to what we were talking about previously, right? So when we're talking about CREAM, I want to just do a little level setting. The requirements for the physical observations and all of that, and not taking an adverse action, come into play when you send someone for a drug test. So we don't do that yet. So one might argue, if pressured, that it doesn't fall under CREAM because there's no drug testing requirement, and the drug test requires a physical evaluation. However, I would say a better practice probably is looking at the guidance and making sure that you nothing in CREMA, none of that requires us. We are still permitted as employers to have drug-free workplace policies. We are permitted to prevent employees from coming to work impaired. We are permitted to prevent employees from bringing cannabis on site and when they're working. But part of recognizing impairment, the guidance is helpful, is having a procedure and a policy in place for how do we do that? What is our practice, right? And I'm gonna kind of take a much more 25,000-foot level approach to this in terms of dealing with employee issues. One of the biggest things that we hear a lot when we're talking about employer-employee issues is we want to make sure that we are treating all of our employees the same, right? So we want to, and part of that means we have a policy that we apply equally to everybody. So having a policy or a practice for how you document impairment, the things that you notice, how you put that down on paper, having that in place and applying it equally and universally to our entire employee population is important. From just a standard practice of kind of how we're managing our employee workforce, because it instills in our employees that we are treating and evaluating everybody on the same basis. When we start making assumptions, I'm jumping off of your question, but when we start making assumptions about folks that we think may be impaired on site, that perhaps take into account their appearance, their ethnic background, what they look like, what they're wearing, that can lead us down a very troubling road of disparate impact, and that you're only requiring certain people to have a drug test. We're only determining that certain people are impaired for this or that. So in terms of, the policies and the statute, I think, a good practice as an employer is to have a policy and a practice of how we deal with impairment, how we document it, and ensure the folks that are doing that, maybe you have 2 people that are witnessing it, you write it down, it's in their file, and you send them home for the day. But having that policy and practice is something that employers should have, and what Larry Landscaper did not have in our earlier hypo, in terms of how we treat all of our employees on a kind of an equal level playing field. I don't know if you want to add anything to that. No?
That's great. Thank you.
Hello, I have a 2-part question, and my question revolves around wire and wire education, what it will potentially look like. So I am a substance abuse counselor licensed to the state of New Jersey. Would a substance abuse counselor or someone that is clinically trained be qualified to make these types of assessments? That is my first question. My second question is, in your perfect world, what would wire training consist of? What would be the best type of education or scenarios that would certify an individual to be a wire specialist? Thank you.
I mean, I can non-answer it, but go ahead. Yeah. So I think that's an excellent question for folks over at the CRC that are putting together the regulations as to what a certification looks like. We don't have it. We don't know what it is. The only answer I can provide is kind of what is in the statute. And what it talks about in the statute is that the CRC is going to prescribe minimum curriculum courses for study for certifications, as well as standards for the commission's approval, continuation of nonprofit and for-profit programs, organizations, and schools. And it may also include use of the Police Training Commission approved school if consented to by the Police Training Commission. You're going to, I'm sure, hear from some of my esteemed colleagues, one that's sitting over there, about drug recognition experts and kind of how these two things tie together. And I think that if you look at how the statute was enacted and where the language came from, they were tying wire certification sort of to this DRE certification. They were supposed to kind of go together. Now doesn't say that, but if you're looking at a lot of the discussion, that's kind of what was, I think, assumed. But the certifications, the curriculum, it just doesn't exist yet. They haven't put it into place. All we do have is, some limited guidance on someone that just can observe impairment, but we don't have that. But I think your point of who would be qualified is definitely something that should be considered as they're putting out these regulations, or if they put out the curriculum regulations, and maybe expanding that would be a way to bring more people under that umbrella. But I don't have a specific answer to that question. I don't know if you all want to add to that.
I'm just going to stand because I don't want to be rude, sir, and I can't make eye contact with you from where I am here. But I want to thank you for that very thoughtful question, because one of the things that Ruth and Michael and Mike Kelly and I have been thinking about is the wonderful opportunity that the Cannabis Regulatory Commission actually has before it to talk about this problem. It would be intellectually dishonest to deny the fact that we need guidance. There are a lot of scenarios, not just the hypothetical that we had some fun with here today, to talk about what should happen. And if we are a Fortune 50 company that have in-house resources to do technical training to tens of thousands of employees or hundreds of employees, that's one thing to consider. But if we are to look at the interim guidance as it exists today from September 9th, 2022, aspirationally, there's consideration of a standard operating procedure for inclusion in a handbook, which might not exist given the resources of that employer, to talk about the sample reasonable suspicion observation form, which may or may not be used universally. Aspirationally, there should be independent corroboration by a second individual, preferably someone of a managerial level or an outside third-party contractor, which gets us back to where you invited us to go. Who provides the certification? And as of right now, we don't have that guidance. But we ought to recognize that one size indeed not only cannot, but does not fit all. So whether or not, as some of our colleagues have informally discussed, perhaps it's a 1-hour webinar that you tune into and you're certified. Perhaps it's a 40-hour gold standard course, not unlike an OSHA course. We just don't know how that's going to roll out. Will there be annual trainings? Will it be one and done? Will you have to do it for other matters, not just impairment? And to steal, well, actually not to steal, but to credit actually Ruth, because I think she has properly framed the question. Rather than talking about impairment, which is cognitive, or intoxication, which is blood-based, maybe we just talk about fitness for duty. And if an individual in the workplace is not fit for duty and presents a clear and present danger to either themselves or their coworkers, the vehicular or pedestrian public, maybe that's where we ought to drill down. And I would strongly encourage you, when some of our colleagues from the Cannabis Regulatory Commission will be joining us at the lunch break and beyond, to pose that very thoughtful inquiry to them. And I thank you for this opportunity.
Hello, I was going to ask the question, because clearly the adult use statute does not have any clear, we come to this conclusion, it doesn't have any clear certifications, guidelines to what constitutes impairment, what constitutes the inability to perform your duties. On a state level, local businesses, corporations aside, federally it's still illegal to test positive on a drug test, and I'm assuming as a state of New Jersey employee that's also the case. Yet while this is clear, doesn't that provide a loophole to justify, oh, I can use marijuana recreationally, adult use, on my own terms at work, even if I am a state employee? Then again, the federal government and the state of New Jersey has different regulations. My main question regarding this is, since there are no clear, definite guidelines, where do we go from now, and what will in the future constitute that? Because I could say subjectively what I may be a danger to myself or others, or you may be a danger to yourself or others, is subjective. What is your term of danger? What is my definition of what constitutes a danger?
I'm going to start with part of that, and then I might pass it along to some others to comment. I want to just draw a little bit of a distinction about the beginning of what you said, because I want, again, maybe I'm just like level setting here. Drug testing and a drug-free workplace are two different things. They're two different things. So when we're talking about the Federal Drug-Free Workplace Act, and we're talking about the federal prohibition, there are court cases out there that say the Drug-Free Workplace Act does not require employers to drug test. There's no federal requirement that private employers drug test. There are specific federal regulations that require some classes of employees to be drug tested. For example, Department of Transportation. If you're going to get a CDL license, you're going to have to pass a panel of drug tests, which includes cannabis. That is a federal statute. The state statute takes that into account and says, look, if this conflicts with federal law, you have to follow federal law. So I just want to say kind of from the beginning, the drug testing and drug-free workplace are two different things, right? So when we're talking about, what we're talking about here is drug testing and impairment. So, when we send someone for a drug test and how we do that and how we link that with impairment, I think is probably getting more to the heart of your question. And I'll go back to some of the things that David said. It's, it is subjective to a certain degree to determine impairment. But what I will also say is employers have been terminating people for coming to work impaired long before CREMA was passed, long before we had medical adult use cannabis. So we have tools to do that. But the wire issue is kind of taking that funnel and making it a lot more narrow to the extent we ever get those certifications as it comes to cannabis. But I'll let my other panelists weigh in on that as well. Nothing else? All right. Oh, question.
Caveat here, practicing attorney, California and New Jersey. I do represent a lot of small businesses, 25 employees or more, and so I do believe this topic is pretty relevant to my practice. And my question, maybe for Ruth or David Squared, is independent contractors, and I mean genuine independent contractors, not strawman ones where the employer controls the work and services and things like that. But for an independent contractor with a valid agreement, does CREMA in New Jersey apply to, let's say, terminating an independent contractor who potentially is Stevie Stoner that shows up?
I mean, I don't have the definition section in front of me, but it's going to depend on how employee is defined in the statute. And I think it's probably defined pretty broadly in a couple of places, but I don't know if independent, I'm just looking at the specific language on adverse action, and it uses the word employer and employee. I don't know if it includes independent contractor.
Yeah, I didn't know either.
Yeah.
Figured the
So
experts would know.
I don't know the answer to that one as I'm sitting
It's
here.
my understanding it does, but I think it would be worth looking into.
And a second question is, obviously the ADA applies to a certain threshold of employees, right? Yeah. So does that apply here for CREMA as well? Is there like 2 employees or more, 25 or more, 50 or more?
I don't believe that there's a numerical requirement to be covered by CREMA. I think it's just any employer in the state. I don't think. I'm not positive.
Actually, I mean,
The gray area.
questions until, well, later speaking. If there is. Oh, I'm sorry, I didn't see. He gets to go before I do. I'm sorry, I didn't see you.
Just hold it really close to you.
So I just had a 2 questions, and the first one is a clarification question. You said that the wire and having a certified person to fill out that form is not required yet. It's recommended.
The certification process that is required to certify someone as a wire has not been issued yet by the CRC. And the only regulation that exists right now from the CRC on a wire says at this time the physical examination portion of that doesn't apply. But what you do have is guidance that talks about what you can do to document impairment for reasonable suspicion.
Okay, so I guess my second question would be, without that documentation and without a drug test verifying impairment, because obviously somebody could have used cannabis a previous day and then not come into work and still test positive for that, what actually is determining impairment purely subjective? And if it is, what action can be taken to I guess what action can be taken to punish, I guess, that person for being impaired if you can't actually prove they're impaired, whether or not, even if they did come in impaired, you can't really say they did, right? Yeah. So how could you, I guess, what action could be taken against that person?
I mean, I think he hit the nail on the head, right? In terms of the issue, right? So I think it goes back to the bigger point of presence doesn't equal impairment. Cannabinoids stay in the system for a long period of time. Exactly what you're saying, right? You just don't know if that person is, if the positive drug test demonstrates impairment. And really, I think that the intoxication test, as David said, which is the medical test, and then the impairment, that you're trying to match those two things up to say this is what we think it is. But is it subjective? Based on the form, a human being is filling that form out. So I think, to some degree it is, even though there are articulable signs that are laid out in the form that are checked. I'll let you all weigh in on as well.
The two gentlemen seated immediately to your right are champing at the bit to talk about that because they are two of the thought leaders in the state of New Jersey where drug recognition expertise comes to bear. But I will just, if I can have 30 seconds. The notion of WIRE, the acronym W-I-R-E, the E stands for expert, and for those that have indulged me by listening to me prattle on about this previously, those of us that are licensed attorneys, an expert actually means something. You have to be qualified under a United States Supreme Court case called Daubert, D-A-U-B-E-R-T, and since 2018, the New Jersey State Supreme Court, in a case called In Re in the matter of Accutane, A-C-C-U-T-A-N-E, has adopted the Daubert standards. To any licensed attorney in this room, expert means somebody who has a curriculum vitae, not unlike our colleagues that have doctorates in the room. And it means that there is a scientific reliability to the testimony that you will give to the finder of fact, which is what a jury is in the United States. You will help them to understand the complexity of the issue without resolving the ultimate conclusion for them, which is impermissible. To turn around and tell anybody that it's a layperson in the state of New Jersey that they are going to be an expert speaks to the kind of subjectivism that you question at this point. And I don't think there's going to be any way, in the absence of empirically reliable technology, which the state of the science, as Mike Kelly will tell you in just a bit, has not evolved to that point. It's going to be, by definition, a subjective process of good faith and reasonable suspicion. But I am and have been greatly troubled that E remains expert and not simply perhaps evaluator, which I would submit is a much lower standard, which recognizes the inherent subjectivity of the assessment. Thank you.
All right, Kim, do you have one more question? Or?
Well, I think, you know what, I'm going to have to defer for the sake of time. I really hope you all can stick around.
Thank you.
And thank you so much.